So somebody once said that for any law to have recognition in society, it must first be acceptable to all people in the particular society. So I want us to discuss this statement in relation, to the functions of law in society, and we also want to analyze whether law has been effective in achieving its goals. Now, the statement that for any law to have recognition in society, it must first be acceptable to all people, raises a key jurisprudential debate, and that is whether legitimacy of law depends on social acceptance or on legal authority alone. So this reflects, the tension between legal positivism, which holds the view that law is valid if properly enacted, and also the sociological theory of law, which holds the view that law must reflect societal values to be effective. Now, modern constitutional systems like Kenya, show that law is effective only when it balances authority, when it balances legitimacy and social acceptance. Now, what is the meaning of law in society? You see, law is a system of rules enforced by institutions of the state to regulate behavior and maintain order. According to Roscoe Pound, law is social engineering aimed at balancing competing interests in society. Now, what are the functions of law in society? Now, the first function of law in the society is maintenance of social order. You see, law is meant to regulate behavior and prevent chaos. If you look at the case of Republic versus Dudley and Stephen, the facts of this particular case were shipwrecked sailors, killed a boy and ate the boy to survive. And the issue was whether necessity was a defense to murder. And the rule is that murder is strictly prohibited. And the application of this particular case was that the court upheld the conviction. And the conclusion of this case is that law maintained, moral and social order. Now, the function of this case was that law preserves order even against moral pressure. The second function of law in society is protection of rights and freedoms. You see, law is meant to safeguard individual rights. If you look at the case of Mitubel Welfare Society versus Kenya Airports Authority, the facts of this particular case concerned, forced evictions of informal settlers. And the issue was whether eviction violated constitutional rights. And the rule was Article 43 of the Constitution of Kenya 2010, protects housing and dignity. And the application was that the court ruled that the evictions were unconstitutional. So the conclusion of this particular case was that rights were actually protected. So the function of this case is that law protects vulnerable groups, including women. Now, the third function of law in society is promotion of justice and equality. You see, law ensures fairness and non-discrimination. If you look at the case of Rono versus Rono, the facts of this particular case were that daughters were excluded from inheritance. And the issue was whether discrimination was lawful. And the rule was Article 27 of the Constitution of Kenya 2010, which guarantees equality. And the application was that the court struck down discrimination. And so equality was actually upheld. Now, the function of this case was that law promotes substantive kind of justice. The fourth function of law in society is social change and transformation. You see, law is meant to reform society. If you look at the case of Trusted Society of Human Rights Alliance versus Attorney General, the facts of this particular case was, challenge to public appointments lacking integrity compliance. And the issue was whether Chapter 6 of the Constitution was enforceable. And the rule is that leadership must meet integrity standards. And the application of this particular case was that the court enforced constitutional values. And so the conclusion of this case was that integrity requirements are actually binding. Now, the function of this case was that law transforms governance type of culture. The fifth function of law in society is resolution of disputes. You see, law provides structured mechanisms for resolving conflicts. Example is through, courts, through tribunals, and also through ADR systems under Article 159 of the Constitution of Kenya 2010. The fifth function of law in society is social control. You see, law is meant to regulate behavior and discourage deviance. A good example is traffic laws, criminal laws, and also environmental laws. The seventh function of law in society is economic regulation and development. You see, law regulates trade, it regulates taxation, and it also regulates investment. A good example is, contract law ensures commercial certainty. Now, what is the role of acceptance in legal effectiveness? Now, the statement suggests that law must be socially acceptable. And this is linked to Roscoe Pound, who argued that law must reflect social interest. Now, the first role of acceptance in legal effectiveness is that law gains effectiveness through acceptance, so that when society accepts law, compliance increases and enforcement becomes easier and legitimacy strengthens. A good example is that constitutional rights are widely accepted, and you see this has led to higher compliance. The second role of acceptance in legal effectiveness is that law without acceptance becomes weak, so that if law is rejected, enforcement becomes difficult and resistance increases. A good example is where you have some customary or moral norms conflicting with modern law. Now, let's look at the legal framework in Kenya. You see, the Constitution of Kenya provides the foundation for lawful authority. Article 10 on national values talks of the rule of law, it talks of participation of the people, it talks of human dignity and also equality. Article 159 on justice states that justice shall be administered without undue regard to technicalities. Now, these constitutional provisions aim to make law both legitimate and acceptable. So, has law been effective in achieving its goals? You see, the first thing when it comes to whether law has been effective in achieving its goals is, number one, areas of effectiveness. You see, under area of effectiveness, we must address, a number of things. We must address, number one, constitutional enforcement of rights. You see, courts have strongly enforced rights. If you look at the case of Me Too Bell Welfare Society versus Kenya Airports Authority, this case shows, effective protection of rights. Under area of effectiveness, we must also address, equality and anti-discrimination. In the case of Rono versus Rono, law, effectively corrected discrimination. Under area of effectiveness, we must also address, number three, governance reform. You see, the case of Trusted Society of Human Rights Alliance versus Attorney General strengthen, leadership accountability. The second thing when it comes to whether law has been effective in achieving its goals is areas of weaknesses. You see, the first area of weakness is enforcement gaps. You see, some laws exist but are not effectively implemented. The second area of weakness is corruption. You see, corruption weakens trust in the legal system. The third area of weakness is cultural resistance. You see, some communities resist legal reforms. The fourth area of weakness is inequality in access to justice, so that poor citizens struggle to enforce rights. The third thing when it comes to whether law has been effective in achieving its goals is the sociological critique. You see, Roscoe Pound stated that law must align with social needs to be effective, so that where it does not, become effective is where law becomes symbolic and compliance actually reduces. The fourth thing when it comes to whether law has been effective in achieving its goals is the legal positivist view. And Hart stated that law is valid if properly enacted, even if it is unpopular. But you see, effectiveness still depends on acceptance. So here is a critical evaluation of the statement that for any law to have recognition in society, it must first be acceptable to all people. You see, the statement is partially correct but incomplete. It is true that law is more effective when socially accepted and that legitimacy enhances compliance. However, it is false that law does not require universal acceptance to be valid, considering, unpopular laws can still function. And a good example are tax laws, because nobody loves taxes, but tax laws are still, in operation in many legal systems in the world. So the modern constitutional systems, combine, legal authority, which is positivism, social legitimacy, that is sociology, and also justice values, which is natural law. The conclusion is that law performs, multiple essential functions in society, including, maintaining order, protecting rights, promoting justice, resolving disputes, and facilitating social change. Cases like Rono versus Rono, Mitubel Welfare Society versus Kenya Airports Authority, and Trusted Society of Human Rights Alliance versus Attorney General demonstrate that law is effective in many areas of governance and social regulation. However, its effectiveness is significantly influenced by social acceptance, by enforcement capacity, and also institutional legitimacy. So that while law does not require universal acceptance to exist, it functions best when it reflects, societal values and when it gains public trust. Therefore, law is both a legal command and a social institution, and the success of law depends on balancing authority with acceptance. My name is Buketi. If it is your first time here, make sure to subscribe to this channel for more legal lessons.